appeal in the matter of the Financial Conduct Authority and BlueCrest Capital Management UK.
Yes, Mr. George.
My lords, my lady, I represent the Financial Conduct Authority this morning with my learned friends Mr. Rattan and Ms. Mayer. Mr. Herberg, King's Counsel, represents BlueCrest Capital Management UK LLP with Mr. Burgess and Mr. Adekoya. My lords, my lady, as this panel will have seen, there are effectively two separate components to this hearing. The first issues on appeal relate to the question of whether the FCA can impose a requirement on a single authorised firm requiring them to make redress payments in the circumstances of this case. And if it can, what are the jurisdictional limits to that power? And the second set of issues relates to the limits of any hard edge to the Upper Tribunal's jurisdiction to permit amendments to statements of case. And subject to the court, I would propose addressing the issues in that order, which follows the way that both parties have addressed them in their skeleton.
Yes.
And the necessary background to the first set of issues can really be shown in just two short documents. The first is the requirement itself imposed by the FCA, that which is said to be unlawful. And I'm hoping, my lords, my lady, has a supplementary bundle, it's tab 11, page 414 for those in hard copy. We will, during the course of this appeal, be looking in some detail at a number of the statutory provisions in the Financial Services and Markets Act 2000, but this is a supervisory notice, one of the mandated notices. And the court will see at paragraph 1, line 2, the authority has decided to impose a requirement that BlueCrest Capital Management pays redress to certain of BlueCrest's customers. And for present purposes, my lords, my lady, don't need to be too concerned with the actual details at 1A, 1B and 1C. What gives rise to this issue is the fact that it is a requirement to pay redress, and you will see in line 1 that the authority imposed this pursuant to section 55L of the Financial Services and Markets Act, which I'll refer to as FSMA, which is an acronym that's often convenient. The reason the FCA says such a requirement to pay redress is justified is over the page at paragraph 4, page 415. And in terms of the breach, the cause of action, if you like, although obviously it's a regulatory rule rather than something from private law, you'll see in line 2 of paragraph 4, in breach of principle 8, its arrangements for managing that conflict were inadequate. And I will show you principle 8 momentarily, but it is accepted that on the unamended case, the requirement imposed by the FCA was as a result of a breach of that principle and that principle alone. And finally, if the court turns to page 424, this is the annex to the first supervisory notice, the court can see the statutory provisions upon which the FCA relied, particularly at paragraph 2, section 55L of the Act allows the authority to impose a new requirement on an authorised person if it appears to the authority that it is desirable to exercise the power in order to advance one or more of the authority's operational executives.
And was the reference at paragraph 5 to section 404F7?
Precisely. Section 404F7 of the Act envisages, and I highlight that word, that such a requirement may be used to require the establishment of a redress scheme. And so it does, my lord, as we will see in due course. But my lord is right to highlight that paragraph because an issue in the judgment, a fundamental issue in the judgment, was whether in fact the power to impose a requirement to pay redress was created by 404F7 in the first place.
Well, I understand that, but the annex is introduced at paragraph 26, at page 420, as setting out the regulatory provisions that are relevant to the FSN. But is section 404F7 relevant to the FSN on your case?
On my jurisdictional case, no. Because this is not a case.
So paragraph 5 shouldn't really have been there.
Well, my lord, it may well do no harm, but I absolutely excise it and excise it happily in the circumstances of this case.
Thank you.
Now, my lords have obviously seen how the debate has played out. It has been said, and it has been held by the Upper Tribunal, that the statutory provisions on which I rely, 55L, do not permit this sort of requirement to be imposed because there are 4 conditions that need to be satisfied and pleaded under the statutory regime, it has been held, in order that such a requirement can be imposed. And my lord, we appeal against that finding, and that is the first issue of statutory construction that arises. The second group of issues on this ground is that we did succeed in persuading the tribunal that we had in fact satisfied 3 of those 4 conditions. Although we held they were not necessary, it was held that we had in fact satisfied 3 of them, and that is the subject of the cross appeal. The 4th so-called condition, the actionability criteria, it was held we had not satisfied, and we accept that it is not satisfied on our unamended case because a breach of the principles, such as Principle 8, is not actionable in a court of law, and that's as a result of a rule which the FCA made pursuant to its own power to decide whether its own rules should or should not be so actionable. And I will obviously address you separately about the position should our amendment be allowed in this regard, but in principle, on the unamended case, we accept the 4th criteria was not satisfied. So before turning to the statute itself, may I just show you in the authorities bundles, if I may, at volume 1, tab 19, page 396.
Mr. George, are we receiving a transcript?
My lord, I will need to turn behind me. I'm told, yes, it's overnight, is it? It's overnight, my lord, rather
It's
than...
helpful for us to be told because it assists in knowing how detailed the note is.
I'm very grateful. I apologise, my lord. There is a transcript available, and it will be available at the end of each day. So, my lords, at page 396, tab 19 of the authorities bundles, these are the FCA's principles. We will be looking at a number of them over the course of this appeal, but may I just show for immediate purposes Principle 8, conflicts of interest. A firm must manage conflicts of interest fairly, both between itself and its customers, and between a customer and another client. And those definitions of a client and a customer are important for some of the issues that we will be addressing. So, my lord, my lady, with that introduction, may I turn to show you the relevant provisions of FSMA? And I start, my lord, with the one which is front and centre of the first supervisory notice, the one which we say of itself is sufficient to enable us to impose this requirement, and that is section 55L, which is at Authorities Volume 1, tab 4, page 59. My lord sees there, one has to track through the subsection, but at subsection 2, the FCA may exercise its power under subsection 3 in relation to an authorised person with a Part 4A permission if it appears to the FCA that, and the court can see there are 3 specified criteria, which are the trigger points to the FCA being able to exercise the power in subsection 3. For the purposes of this case, the relevant one is subsection C. It is desirable to exercise the power in order to advance one or more of the FCA's operational objectives. And then in subsection 3, what is the power that can be exercised on those trigger conditions? The court will see there are 3 such powers, and 3A is the relevant one for these purposes, to impose a new requirement. And then at subsection 4, it's given its own name, the own initiative requirement power. And my lords, my lady, there are many more statutory conditions to show, including ones that both the tribunal relied upon and I rely upon. But I pause here in section 55L to make our primary submission, which is this as a statutory provision is of itself sufficient to enable us to impose the requirement that we seek to impose in the circumstances of this case. It is not, as the court will see, an unfettered power. It is not a power that does not have trigger conditions. Those are clearly set out, and we make our case that the relevant one, that in 2C, is satisfied. And of course, any exercise of this power is subject to the standard public law principles, including that the authority must act rationally in the exercise of its statutory power. So it is unfettered both on its own, it's not unfettered both on its own terms and by reference to standard principles of public law decision making. And my lord, there is additionally a particular safeguard within the statute itself. If I can invite you to turn to page 74, this is section 55Y, and the court sees there the heading exercise of own initiative power, procedure, and looking at the page to subsection 5, if that power is exercised, a notice must be given, contains various requirements, but in C, inform A, he or she who is receiving the notice, that they may make representations to the regulator within such period as may be specified in the notice, whether or not A has referred the matter to the tribunal. And then over the page at page 77, whether or not they choose to make representations to the FCA, if the court has section 55Z3, subsection 1, an applicant who is aggrieved by the determination of an application made under this part may refer the matter to the tribunal. So the supervisory powers, the remedy, if it is said that the FCA has acted in an unlawful way, are for the matters to be considered by the specialist tribunal Parliament has set up to consider these types of specialist matters. And that will consider questions of fact and law, as well as questions of what one might call unreasonableness in the judicial review sense. And that is all, of course, matters which can and will be considered at the substantive hearing of this tribunal.
So the Upper Tribunal can apply public law principles. It's not a question of having to judicially review on public law grounds.
And it makes factual findings. And I'll show you the exact remit, which depends on whether it's a disciplinary reference or a non-disciplinary reference. But even in its more restricted sense, the non-disciplinary reference, it makes findings as to fact. And it is unfettered in the findings of fact or law, which it can make. And those will include and have been set out in the authorities to include that which a judicial review court would take into account. So in addition to the, and of course it will consider the construction of the actual statutory trigger criteria itself.
So when you said that any exercise of a power was subject to standard public law principles, normally that would mean you'd be subject to judicial review, but this ousts judicial review, at least until you've gone through this process, is that right?
There are a couple of Court of Appeal authorities in which it has been suggested that in very, very specific and unusual circumstances, you might be able to challenge the earlier process, but broadly, in the majority of cases, this is the alternative remedy. There is full power in the Upper Tribunal, and
so you need to use the alternative remedy in preference to apply judicial review.
Precisely. And if you do, then the Upper Tribunal will consider all of those issues, and that is the trial that we will have in this action, given the issues that have arisen between the parties.
Just so I understand, though, as you say, the tribunal has the power to make findings of fact and law. But as I understand it, on your case, let's just assume, for the sake of argument, that the findings of fact are made in accordance with your statement, the authority's statement of case. Can you just clarify what role the tribunal would then have on your case, for example, in assessing whether the quantum of the redress is the right quantum?
There are two answers to that, because obviously, firstly, and there's a lot of detail in the pleadings, there are questions of fact that go to quantum, if I can put it that way, because it is said that we have applied an incorrect rate, that we have not taken account of the fact that non-US investors were not pension funds, for example, and so we've applied certain rates that will be applicable to pension funds. It said we've not used the correct market average in dealing with this type of fund. So there are factual questions.
Yes, I suppose that gets to my point. You're making comments that might be said to relate, for example, to quantum of loss, but the authority's case is that questions of loss aren't really relevant. So how do all of those points play in?
Well, these will, of course, be matters for the tribunal.
Well,
In considering the matters in what I've called public law principles, but it will in fact be the tribunal, it will be necessary for the tribunal to be satisfied that there is a rational approach to the fixing of the payments of redress in that case.
So it's public law principles. It's
Precisely.
whether you can justify them as a rational decision
Precisely.
for the consumer protection objective that you pray in aid.
Precisely. And I'm not going to foreshadow the debate, but one can quite see that my learned friend's factual case at its highest is effectively, well, this is totally irrational because there wasn't really any loss, or it's not a fair proxy that you're using for the loss. Those are the types of issues.
I think they also say we didn't do anything wrong.
Yes, and of course there's a prior question if we didn't breach the principle at all.
Yeah. And so this is not, it's not quite like a judicial review because you're going to hear witnesses and make findings.
Exactly.
So it's sort of judicial review plus
Definitely.
public law principles, but starting again with the facts.
Precisely. And that, in a sense, in my respectful submission, is a key point in looking at the statutory jurisdiction and whether it needs to be limited in the way that has been held by the Upper Tribunal, because all of these factual matters will be looked at.
You've shown us the statutory provision under which people can refer the matter, whatever the matter is, to
Which
the
we will,
tribunal.
precisely.
Are there statutory provisions telling us what the tribunal's jurisdiction, once the matter's been referred, is? What
Yes,
the tribunal can do?
And they're at page 99, if we perhaps turn them up at this point.
Well, whenever you want to get.
I mean, it may be useful because it obviously logically follows from my Lord's question. So section 133. So you see in subsection 5, in the case of a disciplinary reference, and that broadly is the fine in this case, the fine for misconduct, a disciplinary reference, the tribunal must determine what, if any, is the appropriate action for the decision maker to take in relation to the matter, and on determining the reference must remit the matter to the decision maker with such directions, if any, as the tribunal considers appropriate for giving effect to its determination. So returning to my lady's question, when there is a disciplinary reference, the tribunal has full discretion simply to decide what the appropriate fine is. There's no need to be hamstrung by the FCA. Subsection 6 relates to the redress scheme and other what are called non-disciplinary references. In any other case, the tribunal must determine the reference or appeal by either dismissing it or remitting the matter to the decision maker with a direction to reconsider and reach a decision in accordance with the findings of the tribunal. And you'll see those findings in the next subsection are issues of fact or law, which is where this wider jurisdiction comes from to create all these issues of fact. The matters to be or not to be taken into account in making the decision, and the procedural or other steps to be taken in connection with the making of the decision. And that's really why I summarise it as judicial review principles, or judicial review plus seems to me an entirely fair categorisation. Because in addition to what one might call the usual judicial review considerations, what has to be taken into account, what's a relevant consideration, what's an irrelevant consideration, and procedural steps, which obviously are bound up with procedural fairness, these issues of fact or law are there for the tribunal. And you will have seen from the judgments, my lords, my lady, that what is said is that the power to impose a consumer redress scheme must be constrained beyond the conditions set out in section 55L to avoid absurd and unreasonable results. I'm going to turn that up in the core bundle, tab 15 at page 291. this is perhaps the paragraph 283, the core of the tribunal's reasoning. When considering the proper construction of the relevant provisions, we have taken into account whether the authority's interpretation of its powers is consistent with Parliament acting reasonably. We consider that the power to impose a consumer redress scheme on a single firm by virtue of section 55L and the provisions I've shown you must be constrained beyond that asserted by the authority so as to avoid unreasonable or absurd results. And they go on in the next paragraph to refer to sections 404 and 404A, which my lord adverted to earlier. But our first stop on this statutory journey, in my respectful submission, is that of itself was a wrong conclusion. We put it in our skeleton as the first full step the tribunal made. Because obviously, having found that 55L was unreasonable and absurd, if simply restricted to that which is set out on its face, that is then a significant force in the reasoning which takes us into other statutory provisions and the importation of other criteria. In my respectful submission, 55L is a perfectly sensible and rational scheme when seen within the context particularly of the supervisory role of the tribunal. My lord, if one looks at our skeleton, and I won't obviously read everything out, but we deal at paragraphs 19.3 and 19.4, which is page 98 of the core bundle. We just highlight a number of statement of principles from different authorities. And these are not in the bundle because, and I apologise for the length of the authorities bundle, but there are some, in accordance with the practice direction, we have excised and removed, and they're not here because the point of principles are not in dispute. The degree of discretion afforded by such statutory language is well recognised in the authorities. One reference to the phrase, as it considers appropriate, as being the language of discretion. The reference to a duty to provide such facilities as they consider appropriate as a form of words apt to give considerable latitude to a local authority. And perhaps the court might be willing to read paragraphs 19.3 and 19.4 just to see. I don't say they are analogous in terms of it being the same wording. But what I do say is that they are helpful guidance that a court should be cautious before it reads down the clear words of a statute, particularly a statute which has its own triggers and has set those out within a clear statutory scheme.
Well, speaking for myself, if there are authorities which are referred to in the skeleton and relied on in oral argument, it is usually useful to have them.
My lord, and we will provide
the
that
bundles.
overnight. We were, and I apologise for that, we were trying to strike the right balance, and there have been discussions between the teams between too much and too little, but
Thank you.
I will provide those that are set out there. So, my lord, that is our first submission, if you like, and there's so much more to see, as it were, but we do invite the court to start from section 55L, but it is not absurd or unreasonable to read it in accordance with its terms. My lords, if one has the core bundle and one goes to page 282, so you can see the ambit of the argument before you. This is back in the judgment, paragraph 236. These are what you will have seen referred to as the four conditions. So contrary to my case, it has been held that section 55L, if you wish to use it for redress purposes, you must establish that a person has suffered a loss, that loss or damage has been caused by a wrong on the part of an authorised firm, that the loss or damage was suffered by a person or persons in respect of whom the wrong was committed, and that the relevant wrong be actionable. So, my lord, those are what has been interpreted by the tribunal as requirements for the power in section 55L. So, my lord, may I now turn to my second piece of the statute, which is at page 64 of the Authorities Bundle, Volume 1. And this is section 55N. Now, my lord, I'm not overlooking a chronological point that features very highly in the tribunal's judgment, and I will come on to it. But equally, in my respectful submission, this court is construing a statute as it stands today, or at the relevant time this decision was taken, and at that time 55N was very much part of it, and had been for pretty much a decade. And my lord will see that these are, from the heading, page 64, requirements under section 55L, the relevant one today, further provisions. And then at 55N1, a requirement may in particular be imposed so as to require the person concerned to take specified action, or so as to require the person concerned to refrain from taking specified action. Perhaps the court could glance briefly over subsections 2 and 4, which contain further clarificatory in our submissions provisions as to the requirements that could be imposed. And then at subsection 5, a requirement may refer to the past conduct of the person concerned, for example, by requiring the person concerned to review or, and I highlight that word, take remedial action in respect of past conduct. Now, my lord, one can see from the word may repeated in each of these subsections that this is not purporting to be an exhaustive list of what can be imposed under section 55L. But in my submission, if there were any doubt, and I do not suggest there is any, that section 55L entitles a redress scheme to be imposed on a firm, this puts the position beyond any doubt, because what we are clearly doing in this case is requiring BlueCrest to take remedial action in respect of past conduct. And my lord, without wishing to try the court's patience, we do here, and on just one other occasion, refer to a dictionary definition at 2534 of the bundle, in the authorities bundle, simply because, as I will show my lord, there is a dispute as to what the word remedial means in this context.
Sorry, where are we going?
2534 in the authorities bundle.
Can you give me a tab number?
I can, it's 94. And we do highlight it as we highlighted it below. And remedial action is intended to correct something that is wrong or to improve a bad situation. And our respectful submission is that remedial action clearly includes making payments to those in respect of whom breaches of duty have occurred. And I highlight that because that is the second stage where we part company from the tribunal in this analysis, and that's going back to the core bundle and the judgment, if the court has page 297. Here I invite the court to paragraph 314. They say there, we therefore consider that section 55N was not intended to provide the authority with an independent power to impose a requirement to pay redress. Rather, as explained below, the remedial action referred to was intended to denote such activities as a review of past business. And my lord, in our respectful submission, that is an unsustainable conclusion given the statutory language. The example, and it is only an example given in section 55N5, is requiring the person concerned to review or take remedial action. The remedial action is something different to the review, and in our respectful submission is self-evidently the remedy for that which has gone wrong. And we say that that is an unsustainable conclusion. And of course, my lord, my lady, you'll see going on in the paragraph that they say, well, even if we're wrong about that, we rely on section 404 F7, which I will turn to. But before we come to that, as a matter of language in my submission, 55N clearly provides for the type of redress payments that we are requiring here. And then at paragraph...
But have I understood your case that that is only clarificatory because before this came in 2012, there was such power in any event?
Exactly. That's why, at the risk of having laboured the point, my first submission is 55L, and one can stop there. That would be my, that's my primary submission. But if further reinforcement is required, yes, 55N, I say, is clarificatory. On any view, it exists. And if I'm wrong that the power didn't exist before, it clearly exists as a result of 55N. But my lord is absolutely right. In my respectful submission, it was there all the time in 55L.
But what do you say? Because, again, tell me if I'm wrong, the other bits of what are in 55N were all in the predecessor legislation, I think. So it's 55N5, which is what's new and comes in 2012. Have I got that right?
My lord, yes. Let me just check whether there were any other provisions of section 45 that were interpolated. It may, I mean, my lord will have seen that the original powers was 45, which was what then becomes 55L. My lord, I will revert to this because I'm being told, and it is my recollection, in fact the whole thing is new, that 55N incorporates a set of clarificatory provisions which did not appear in FSMA as enacted in 2000. That's right. I'm told that's common ground. I mean, we'll check it anyway.
But this is all new, is it?
It's all new.
Oh, I've got that completely wrong. Thank you.
Well, I apologise. I will check. It may well be my lord has picked something up that we haven't, but that's my understanding. And obviously, one of the reasons that we say it is clearly just clarificatory is because self-evidently a requirement could always have required a person to take specified action. It's hard to think of a requirement that neither asks someone to take specified action nor asks them to refrain from taking specified action. So that always has to have been in there. But they set out this useful clarification. Subsection 2, I can see in a different type of case, one might have had an argument about whether that was within the original provision. Extend to activities which are not regulated.
Sorry to slow you down, but I think what I had in mind was section 43 in relation to imposition of requirements, which I've got at Authorities Bundle, Volume 1, Tab 2, page 10.
Yes, my lord. Yes, exactly.
And that this is FSMA as originally enacted, as I understand it.
That's right. I'm very grateful, my lord, for
and
that.
And that's where I thought I got
Exactly.
43 did have all of them except for 55N5. So that's what the new one was.
Yes, and there's an addition to subsection 4. That may not make any difference.
But what do you therefore say was the purpose of specifically adding 55N5 in relation to past conduct to what was already clarificatory before?
Well, my lord, I make two submissions in that regard. The first is that what is to be clarified is the fact that 55L on its terms permits the imposition of this type of scheme. Why did that need to be clarified? And leaving aside questions of fact, but on a respectful submission, my lord, one sees from this case that there are arguments, the tribunal have been persuaded, that it is possible to reach a construction of 55L, and indeed the tribunal did, which reaches the opposite conclusion. So 55N5 clearly clarifies that. I can also accept, my lord, although I don't think below anyone was able to show any express connection, that coming in 2 years after 404 F7, which on our submission presupposed that the power was there in 55L, and my lord will come to 404 F7 and you'll see the textual arguments. It may well make some sense to specify here in subsection 5 that that is something which is within the 55L power, given there was now a new statutory provision that presupposed the existence of that power, and this puts beyond any doubt. So in our respectful submission, those are the reasons, as it were. But returning, if I may, to the submission as to where we are, just looking at 55L and 55N today, and regardless for the moment of the chronological point, certainly between them in our respectful submission, there can be no suggestion that we are not under 55L, whether interpreted with 55N or otherwise, entitled to impose this type of redress requirement, and furthermore, that none of the 4 conditions appear in any way, certainly not expressly, and in our submission, not by implication, but there's not even a hint that they are some form of the requirements of section 55N. And my lord, showing, if I may, the third area where or the third point at which we part company from the tribunal on the interpretation of 55L and 55N, may we go to page 297 of the bundle. So I've shown you 314, where they say, oh, well, remedial just means review, and I have made the submission that's simply unsustainable. And then at paragraph 316, but even if section 50N5 does provide a power to require payment of redress, or on the authority's case clarify the extent of the power under section 55L, then the reference to remedial action equally requires that the authority establish the 4 elements of loss, causation, duty, and actionability. These are integral to the concept of remedying a wrong done by the firm to an affected consumer. And in our very respectful submission, that is also an unsustainable conclusion. I can quite see that when one's considering the rationality of a scheme that is imposed, one needs to see reasoning as to why it has been imposed, and one might well expect loss or causation. I'm not suggesting they are entirely irrelevant. But it cannot be right that actionability is integral to the concept of remedying a wrong done by the firm. The very wrong we are dealing with in this case is a rule that the regulator specifically drafted itself as part of the regulatory scheme Parliament has charged it to set up and police. How on earth can it be integral to a remedial scheme that it is a private law, contractual or tortious cause of action rather than breach of a regulatory rule? And similarly, the duty condition, which in my respectful submission is not easy to grasp or articulate in the first place, is not something that could be integral. Firstly, a number of regulatory rules are not really directed at anyone in particular. Principle 2, a requirement to act with reasonable care and skill, doesn't involve the same concept as the duty of care or working out privity of contract. It's simply no reason why you search for that sort of duty in these cases. So, my lord, whilst this wasn't the principal reason for the tribunal's conclusion, for that we will go to 404. They have made these 3 findings on the language of 55L and 55N, which in my respectful submission are unsustainable. On their own terms, 55L and 55N in my submission clearly allow for the imposition of this requirement without the interpolation of the 4 conditions. And as I say, in our respectful submission, the tribunal fell into error by effectively starting from the premise that 55L is absurd and unreasonable unless we do something to it, And that has led them to an unwarranted and a strained statutory construction when they start to look elsewhere in the in FSMA. So, my lord, those are the two provisions, and you will have identified the two I principally rely on, 55L and 55N. But the tribunal found the four conditions by a two-step exercise that begins at section 404F7. And I say two-step because it's important for the court to realise that the tribunal's reasoning has two steps, not just one. Firstly, it says that the source of this power in the first place was section 404F7. We say they are wrong about that. But even if they are right about that, that does not get you any of the four conditions in our submission. That simply means that 404F7 created the power and 55N then puts it in a more logical place 2 years later. To get the four conditions, the tribunal go from 404F7 to 404 and 404A in a quite unwarranted way in our respectful submission. And I will deal with both of those issues, but it's important in our submission that we make the point that even if we're completely wrong about 404F7 being the source of the power, that doesn't mean that the four conditions come in. So, my lord, may we go to page 193 of the authorities bundle, my lord, my lady.
So sorry, where are we going now?
193, tab 4 of the authorities bundle. The first volume of the authorities, I'm grateful. So this is
I've got my FSMA provisions loose, so if you could just give me the section.
404F.
Thanks.
The court will have noticed it is probably the least helpfully enumerated and numbered statute after a number of series of amendments, but this one is 404F at its subsection 7.
Yes.
And I will just read it out as it's so central. If, and I again draw attention to that word, if the FCA varies a permission or authorisation of a person so as to impose requirements on the person to establish and operate a scheme which corresponds to or is similar to a consumer redress scheme, the provision that may be included in the permission or authorisation as varied includes, and then we'll look at the two respective subsections, provision imposing requirements on the person corresponding to those that could be included in rules made under section 404, and provision corresponding to section 40B. And my lord, my lady will appreciate why I draw attention to that word if, because in my submission, that clearly indicates that the draftsperson of this statutory section was working on the premise that the FCA already had a power to impose a requirement to establish and operate a scheme which corresponds to or is similar to a consumer redress scheme. And what this statute is saying is that if they exercise that power, then they may do two new things, and I'll look in detail at what those two new things are. But what it is not doing is creating for the first time a power on the FCA to create such a scheme. Because the draftsperson would have been well aware of how you would draft that sort of power. You would say, under subsection 7, the FCA may vary a permission or authorisation so as to impose requirements. The draftsperson of this statute clearly did not consider that any such drafting was necessary. The power existed, and that's why the word if was used. My lord and my lady sees in my submission this made crystal clear at subsection 8 below. In subsection 7, the reference to the variation of a permission or authorisation by the FCA is a reference to the imposition or variation of a requirement under section 55L. So, in addition to the word if being used, we can see they did not think they were creating a power because they knew where the power came from. They knew where it pre-existed. Section 55L. Now, my lord, this is where the chronology is a little fiddly, because when 404F7 was first enacted, it didn't say 55L, it referred to 45, which it then was. My lord has that at page 13, and my lord has looked at it, and it's the same types of trigger conditions. But happily, and I can show you this in the judgment at pages 246 and 248, and the judgment is back at tab 16. So this is page 240, paragraph 246 of the judgment, and here we endorse what the tribunal says. There's no controversy about it. When 404F7 first came in, one sees paragraph 246, by virtue of section 404F8, the variation of permission in section 404F7 was a variation under section 44 or section 45 FSMA. And then if one looks at the bottom, the last sentence of paragraph 248, dealing with the 2012 amendments, section 404F8 was amended by FSA 2012 to refer to section 55L. So the point, my lord, is that when 404F7 was originally drafted, the draftsperson used the word if, indicating that they were well aware that the power pre-existed, and by subsection 8 indicated where that pre-existing power, where the source of it was, which was then 45, now 55L. And again, in our respectful submission, and this is effectively the sort of fourth criticism, specific criticism we make of the tribunal's reasoning, that is a crucial textual point. Whether you agree with it or not, it is clearly a crucial textual point in considering whether 404F7 really is the source of this power, and it is not dealt with in the judgment, and in our respectful submission, it's not dealt with at all. The closest, I put it clearly, we raised it, we raised it a lot below, but if one looks at paragraph 294, at page 292 of the bundle, back in the judgment, the tribunal set out 404.7, and then over the page at 295 they say this: on its proper construction, section 404F7 enables the authority to impose on a single firm a requirement on section 55L3, which corresponds to or is similar to a consumer redress scheme. But there's no explanation of why they think that in the light of the word if and in the light of the powers set out in 404F8. And then, my lord, at paragraph 298, this, we consider that the use of the word may in section 404F7A, as in the provision that may be included in the varied permission, is not intended to be merely clarificatory, permissive, or intended only to provide an example of the type of requirement that the authority is entitled to impose. Rather, it is to permit the authority to impose requirements that, but for 404F7, it would not otherwise have had the power to impose. But, my lord, with great respect to the tribunal, that doesn't address the point we're making in terms of the text. And if one goes back to the authorities bundle, or 404.7 itself at 193, the court will see the word may appears in line 3. The provision that may be included in the permission or authorisation as varied includes, and we don't disagree that absent this provision, absent this word may, we would not have had a power to, for example, bind the Financial Ombudsman Service, which is a third party, and that's what comes in by 404B. So we accept that that which follows the word may does indeed create some new powers. But that doesn't answer or even address the point we made about the word if. The reference to establishing and operating a scheme which corresponds to or is similar to a consumer redress scheme is not governed by the word may, as it could easily have been. It's governed by the word if, which, as I have submitted, presupposes its existence. I mean, to put it in its simplest terms, this is a very clear example of a statute provision that says if the authority does X, then it may do Y. Its ability to do X is presupposed and pre-existing. Its ability to do Y is what may be created by this provision. And the tribunal, in our respectful submission, simply did not address that key textual point. And once you don't address it, in a sense, you in our respectful submission go wrong. Now, my lord, we then come on to those provisions that follow the word may, and it may be helpful if one keeps 404 F7 to hand, particularly if anyone has it loose. So we're back here in page 193, and you will recall the provision that may be included in the provisional authorization as varied includes provision imposing requirements on the person corresponding to those that could be included in rules made under section 404, and provision corresponding to section 404B. And at paragraph 293 of the tribunal's judgment, they say this. Third, section 404 F7A introduced the power for the authority to include in a firm's permission provision imposing requirements on the person corresponding to those that could be included in the rules made under section 404. If it were the case that the authority already had an unfettered power to impose a consumer redress scheme on individual firms absent section 404 F7, there would be no need for subsection 404 F7A of that provision at all. It would be redundant. And my lord, we have two answers to that. The first is, even if there were a redundancy in section 404 F7A or B, that does not justify the tribunal effectively jumbling all the words of the statutory section and placing them in a different order. Even if they are redundant, it doesn't take away that the word if and the reference in 404.8 clearly presupposes the existence of this power. But secondly, my lord, these provisions are not redundant. Now I deal with them one by one. The most obvious one, going back to 404.7. So if one looks at 404.7b, does my lords and my ladies see provision corresponding to section 404b as one of the powers? So for 404b, we go to page 179. And my lord sees that power. If a consumer makes a complaint under the ombudsman scheme in respect of an act or omission of the relevant firm, and at the time the complaint is made, the subject matter of the complaint falls to be dealt with or has been dealt with under a consumer redress scheme, the way in which the complaint is to be determined is to be, as mentioned in subsection 4, which my lord sees over the page, is basically the ombudsman will follow the consumer redress scheme. Now, section 55L, however wide it is, does not, at least on its face of language, allow the FCA to require the Financial Ombudsman Service, a third-party public body which is not an authorised firm, to do anything without 404 F7 permitting the FCA in this type of redress scheme to direct the Ombudsman scheme to act in this way. That power wouldn't exist. So these sections are not, in any view on our respectful submission, redundant. And then if one goes back to page 193 and 404 F7A. And so this is now subsection A, provision imposing requirements on the person corresponding to those that could be included in rules made under section 404. So we go to page 173, which is section 404 itself. And I'll pause here because it's the first time we've looked at 404 to just see what its statutory triggering criteria are. You can see there are three triggering conditions. A, it appears to the FCA there may have been a widespread or regular failure by relevant firms to comply with requirements applicable to the carrying on by them of any activity. So this is a multi-firm redress scheme. We're obviously looking at a single firm in this particular case. 404 applies where there is a multiple number of firms, a widespread or regular failure.
Am I right in thinking that firm, yes, includes authorised persons?
Yes.
As you said.
Relevant firms means
So you
authorised.
could do it if it was just two people at a particular firm. You could satisfy 404(1)(a).
My lord, no. An authorised person is an institution. And in the terminology of FSMA, individual employees are known as approved persons.
Oh, thank you.
The authorised person is the firm that is authorised. So it requires one or more institutions, not simply two employees, my lord.
Thank
And
you.
that authorised approval distinction is maintained in a number of different contexts. So that's the first triggering criteria. Then B, it appears to the FCA that as a result consumers have suffered or may suffer loss or damage in respect of which, if they brought legal proceedings, a remedy or relief would be available in the proceedings. And my lord will see as we trace through, this is one of the sources said to be for the actionability criteria. In a 404 scheme, in a multi-firm redress scheme, you require actionability. You couldn't do it for a breach of Principle 8. But an issue in this appeal is how the tribunal get from 404 to put that requirement into 55L. And then C, it considers that it's desirable to make rules for the purpose of securing that redress is made to the consumers in respect of the failure, having regards to other ways in which consumers may obtain redress. And then if you look at 3, 4 and 5 over the page, the FCA may make rules requiring each relevant firm, or each relevant firm of a specified description, which has carried on the activity on or after the specified date to establish and operate a consumer redress scheme. A consumer redress scheme is a scheme under which the firm is required to take one or more of the following steps in relation to the activity. The firm must investigate whether on or after the specified date it has failed to comply with the requirements mentioned in subsection 1A that are applicable to the carrying on of the activity. The next step is for the firm to determine whether the failure has caused or may cause loss or damage to consumers, and then you'll see payment of redress. So, my lord, as my lord and the court will appreciate, one issue in this case is to what extent is this that similar, the scheme in this case, that similar to a 404 scheme in any event. We are not requiring BlueCrest to investigate themselves and be bound by rules which we make as to how they conduct that investigation. We are asserting there has been a breach and seeking to prove it, and will seek to prove it in the tribunal. It is certainly a different type of structure. So of a classic 404 scheme, you basically, the authority says to the firm, right, you have to investigate yourself, you have to set up and fund this type of scheme.
Well, not necessarily.
Not necessarily precisely.
Subparagraph 4 identifies that if any one of the following,
Precisely.
so that conversely, you could have a consumer redress scheme which didn't involve any compensation at all. It was just an investigation.
Yes, my lord, I accept that.
You must investigate and then report back to us. So,
My lord, yes, no, I accept that. But in a sense,
well, it may be a point in your favour
yes,
because
exactly.
such a scheme wouldn't necessarily posit having to prove that any loss had occurred at all.
No. And if one looks at subparagraph 3, remembering this is the rulemaking power which we're tracing through from 404 FB7, the FCA may make rules requiring each relevant firm, which have carried on the activity on or after the specified date to establish and operate a consumer redress scheme. So it's empowered to impose rules, but as my lord has said, you may have a scheme which does not involve some of these stages. For example, as here, we are not requiring them to investigate breach. Breach is being asserted, but then you might have rules as to how, if they wanted to, they had to investigate X or Y. And so, my lord, one sees, if one goes over to section 404A, what those rules are. And my lord, perhaps if the court was willing to cast its eye over the first four, as it were, these are really matters connected to what is taken into account in a redress scheme, should that redress scheme happen to involve investigation of breach, as we can see at C, kinds of redress at D. And then, my lord, going over to I to M, we see slightly different types of matters which involve third parties. I, authorising one or more competent persons to do anything for the purposes of, or in connection with the establishment or operation of any consumer redress scheme. And my lords in the court can read J, K, and L. And we then pay particular attention and reliance on M as to the enforcement of any redress, for example, in the case of a money award as a debt owed by a relevant firm. Now, there is an issue between the parties as to whether, if 55L is as wide as I say, you could have imposed these requirements on third parties anyway. Can you create a debt enforceable by a third party, potentially having repercussions in insolvency context, presumably, by the imposition of a requirement of 55L? It may well be, looking at I to L, that one could require a firm to allow a competent person to do various things, or to require a person nominated by the FCA to do various things. But these are all provisions which involve the empowerment of third parties. And in our respectful submission, it is wrong to say that they are necessarily redundant. It may be that most of them you could get there under 55L, but we don't see how you could in respect of subparagraph M.
Why not? Couldn't you just require them to give a contractual undertaking to make the payment that you're saying they must make?
Well, in our respectful submission, that is would not quite be the same as to actually prescribe, in a way that would be against all the world, a contractual debt. But, my lord, I accept the premise that it may be that one could have craft a requirement which enables these matters to take into place. But there is no reason in my respectful submission to regard these provisions as redundant in such a way as to change the natural meaning of 404 F7. And as I say, my lord, on any view, 404B is a power which would not have existed absent 404 F7. And my lord sees at 404A9 on page 178, nothing in this section is to be taken as limiting the power conferred by section 404. So, in our respectful submission, the true construction of 404 F7 is that it correctly recognised that there was a pre-existing power to impose a single firm redress scheme under section then 45, now 55L. That is the plain meaning of the word if and the plain meaning of subsection 8. And the powers that are created and permitted by 404 F7 are not, as it were, redundant, at least in the case of the 404B power to bind the Financial Ombudsman Service, which is a crucial provision at the heart of these consumer redress schemes. And in that regard, may I just show one more subsection from section 404, my lord, which is at page 174. So before making rules under this section, the FCA must consult the scheme operator of the ombudsman scheme. So the symbiotic nature of these multi-firm redress schemes and the ombudsman scheme is extremely important, because if you have, let's posit there are thousands of complaints, that's why you're bringing a multi-firm redress scheme. Clearly, the multi-firm redress scheme is an alternative avenue for those to be sorted out, rather than everybody complaining to the ombudsman. And that's why you need to have they need to move in step, and that's why the statute provides it. So our respectful submission is that the power pre-existed the imposition of the enactment of 404 F7, but what 404 F7 does is to provide these important new power. And may I just briefly show how the FCA recognises that in practice, or what its provision is for these two different situations. So if one goes to Authorities tab 71, page 2293, I'll show these briefly because I accept they are the authority's own documents, as it were. This is how we see it, or the FCA sees it, and is reflected in a number of the guidance provisions I'll need to turn to. So this is, as I said, it's a settled redress scheme, so it's a voluntary requirement. But you will see under the second paragraph, TFS, an authorised person with a permission granted under Part 4A of the Financial Services and Markets Act 2000, hereby applies under Section 55L5A of the Act for the FCA to impose the requirement of the Part 8 permission of TFS in the terms of the schedule below. There is only reference here to 55L and not to 404 F7. And my Lord's first question this morning, quite rightly, picked up on our first supervisory notice the importance of getting this right. But the reason there is no reference to 404 F7 here is because this scheme, TFS loans, doesn't need to and doesn't purport to bind the Financial Ombudsman Service. So it's just a 55L scheme. We don't need to use those powers under 404B to bind the Ombudsman. Contrast, if we can, with tab 69, page 2224. And this is a company called Affian International Limited. My Lord, if one goes to 2229, as one see at the bottom of the page, my Lord, requirements imposed in paragraph 12. Under sections 55L and 404 F7 of the Act, the following requirements and provisions are included in the firm's position. So here we have a reference not just to 55L, but also to 404 F7. And we go over the page to 2231 to see why that is. And my Lord sees at paragraph 12.2, certain complaints are to be dealt with by the Ombudsman as described in Annex C on the basis that the redress scheme corresponds to or is similar to a consumer redress scheme under section 404 of the Act. And in our respectful submission, that is the answer to why this statute says what it says in the way it does. The power to impose this type of single firm redress scheme has always existed under 55L, formerly 45. But 404 F7 introduces this important power to bind the Ombudsman, which in a number of cases will be used. Now, my lord, I now turn, before moving on to other statutory sections, to some background material which is relied upon by the appellant and the tribunal in support of their contention that section 404F7 is the source of the power to impose a single firm redress scheme. And it may be helpful if the court is willing to look at my learned friend's skeleton, paragraphs 28 and 29, pages 154 to 155 of the bundle. So I see at paragraph 29, my learned friend relies upon, and the tribunal accepted it was a relevant factor, the white paper for the bill that would become the Financial Services Act 2010 stated relevantly as follows: the FSA has existing powers to impose redress schemes on a firm-by-firm basis, where a large number of consumers are affected. The power of the Treasury to initiate a collective redress scheme on a wider basis is set out in section 404 of FSMA. The government believes there should be new powers for the FCA to require a firm or firms to make redress either on an industry-wide or firm-by-firm basis as appropriate.
I know both sides rely on it, but this is admissible, is it?
Well, my lord, in our respectful submission, we say no.
I'm not quite sure why myself, but
Sorry, my lord, our primary position below was that it is inadmissible. It doesn't help. It doesn't take us anywhere as a white paper. It being the tribunal having held it to be relevant, as you say, I also make the submission that its construction favours us.
well, I understand that. But your primary position is it's not admissible.
We're not persuaded that it is admissible. I mean, it's.
I thought pre-legislative material of this sort was admissible to indicate the mischief.
Well, my lord, yes, exactly. I can't say that a white paper is per se inadmissible, but we do not consider. Let me put it this way:
It doesn't help.
it doesn't help. If it means what it doesn't mean what my learned friend says it means, and it doesn't say what my learned friend says it says, and it doesn't identify the mischief because of that, or at least the mischief that he seeks to rely upon it from. And if I can develop that, because as my lord has rightly said, we rely on this for the first sentence. The Financial Services Authority has existing powers to impose redress schemes on a firm-by-firm basis, where a large number of consumers are affected. Yes, it does. See section 55L, originally section 45. And the last sentence, the government believes there should be new powers for the FCA to require a firm or firms to make redress, either on an industry-wide or firm-by-firm basis as appropriate. Did we get new powers? Yes, we did. The power to bind the Ombudsman, as I have shown you at 404F7B. It's entirely consistent in my respectful submission with the case I'm running, and for that reason doesn't help and doesn't cross that line of admissibility in terms of statutory construction that one would require in order to make a sensible submission that this identifies some mischief or really helps you. It says there are pre-existing powers, so do I. It says that 404F7 or the new Act creates new powers, my lord, and so do I. But what my learned friend relies on, and I will, if I may, chase it through, is he says that existing powers to impose redress schemes on a firm-by-firm basis where a large number of consumers are affected cannot be section 55L, we're not sure why, but must be a reference to section 384 of FSMA, which is a power which it is referred to in a number of contexts, but we meet here for the first time. And section 384 is at page 28 of the first authorities bundles, or obviously my lord's loose provision if my lord has that. I just draw attention, really just in rebuttal of this argument, to 3841B. So this is the power of the authority to require restitution. And amongst the triggering conditions at 1B, that one or more persons have suffered loss or been otherwise adversely affected as a result of the contravention. So there is no sensible way in which one can say, oh, well, a reference in the white paper to a large number of consumers must be a reference to 384, because that allows, that could be triggered whenever one person has suffered loss. If one goes back to their skeleton at paragraph page 155 of the core bundle,
Are you going to tell us what restitution means? Does it have a particular meaning in this Act?
my lord,
Does it matter?
it doesn't, in my submission, it doesn't matter, because although it's set out in the heading, there are a number of clear triggering conditions as to what can be imposed by way of restitution. So what it means for paragraph 382 is that which is set out within this statute, within this statutory section. So that's in subsection 5 on page 29. The power referred to in subsections 1 and 2 is a power to require the person concerned, in accordance with such arrangements as the authority considers appropriate, to pay to the appropriate person or distribute among the appropriate persons such amount as appears to the authority to be just, having regard to the profits appearing to have accrued, to the extent of the loss or other adverse effects, or to both, if they both exist. So
It just means in order to pay money, does it?
well, it does, but having regard to certain prescribed
It doesn't,
factors.
it doesn't mean restitution in the way it's understood in the order.
It does not mean that that which comes under the book, the law of restitution, and has certain well understood private law meanings there.
I mean, specifically, it includes disgorgement of profit.
Precisely. Its powers are circumscribed by and defined by what you see in 384 and particularly 3845. It does not mean anything that Goff and Jones or other learned textbooks would be directing us to. So, my lord, what is said?
And does, sorry.
No, of course.
One of the points made in Mr. Herbert's skeleton in the footnote is that restitution was used interchangeably with redress.
Well, I mean, I'm sure there are examples. I'm not saying there aren't things that say restitution and redress or that the phrase isn't used, but as a matter of statutory interpretation, no. I mean,
restitution is 382, and you've shown us what 3825 enables you to do.
yeah. How can that, I put rhetorically, how can that not be redress?
It's a form of redress, but that's not the same as saying that's what redress always means.
No, exactly.
That's your submission.
Precisely, my lord. I mean, it's you cannot look at 382 and 384, which both refer to restitution, and then look at what you're allowed to do, which is to make a just payment having regards to losses suffered, other adverse effects suffered, or profits illicitly made, and say, well, that is something different as a matter of statutory construction to redress. That is clearly, properly termed, something that could be called redress. There may be other matters that can be called redress. There may be non-monetary matters that might be redress. But it's a matter of statutory construction. And it goes back to the point the court was making, well, how much do these background materials actually really help us? Because obviously, there are doubtless FCA guidance documents which use them in particular ways. But from the statutory purpose, restitution clearly is not being used in a different way to what one understands redress to be. Redress under 404, and that is a consumer redress scheme requiring compensation to be paid under these multi-firm schemes, is clearly the same in its effect as an order under 384 requiring a firm to make restitution having regard to the losses which customers have suffered. The words are being used at least to both cover that ground, whether or not they could be. And that, for today's purposes in my submission, as a matter of statutory construction, is the clear point.
Is the word redress used elsewhere in FSMA other than in the section 404 suite of sections?
I will check that, my lord. Obviously, you've seen it 404 F7, and the adjunct provisions to 404 refer to consumer redress schemes.
Yeah, and indeed it's defined at 404 F1.
Precisely.
But
I'm not aware.
But
I will,
is it a word that's used at all?
let me
elsewhere?
check. Let me check with the word searching powers behind me rather than rather than picking up the whole thing. I'm very grateful, my lord. So going back to this footnote at footnote 10, page 155 of my learned friend Skeleton. My lord has, the court has considered it. You can see what it says. They say that the existing powers to impose redress schemes on a firm-by-firm basis when a large number of consumers are affected must be a reference to 384, not because of what the statute says, which clearly means that one consumer is enough, but because of this reference in, if my lord sees the enforcement guide defined in bold in the footnote as FSA EG, which says where the breach of a relevant requirement by a person, whether authorised or not, results in significant losses, or, and I appreciate I keep emphasising these two-letter words, but or losses to a large number of persons which collectively are significant, it may be appropriate for FCA to use its powers to obtain restitution on their behalf. There's nothing there that says that anyone is supposing that 384 is restricted to a situation where a large number of consumers are affected. Because it says results in significant losses or losses to a large number of persons. So, my lord, in those situations, and it may be worth just turning up, seeing as the white paper was relied upon by the tribunal, what is actually said in this is in the authorities bundle at tab 13, page 282. Now, this is the enforcement guide.
Sorry, I missed the reference. Can you
282 tab 13.
Sorry, in the
Volume 2 of the authorities one.
I do apologise, it's volume 1, but tab 13, page 282. Oh, sorry, my lord, it's probably right on the computer. Yes, I apologise.
So, my hard copy bundle is split into 9 bundles, and tab 13 appears at the front of volume 2, but it may not be the same for
No,
everyone.
my lord is absolutely right. It's the first, not that it's any mitigation, it's the first tab in volume 2. But my lord's quite right. So it's tab 13, page 282. So this is a section which only...
So what is this document?
This is from the enforcement guide, and it is...
Is this what explains what 384 is intended to be used for?
This is the FCA's internal guidance as to its policy for 382 and 384. And it was what we just looked at in footnote 10 of my learned friend Skeleton. I appreciate it's a bit convoluted, but he relies on it against me to say that from this document, you can see that the reference in the white paper for pre-existing powers to order payments on a firm-by-firm basis has to be a reference to 382 and 384.
Can I say, just as a matter of housekeeping, it's obviously sensible just to have an extract from the document rather than the whole document. It is useful to have a cover sheet.
Cover
which
sheet, yes,
explains
and
what it is, who's made it, what its title is, and what its date is.
my lord, I accept that, and we will see if we can find that for the. But this is an enforcement guide.
Yeah.
And you'll see immediately this. I mean, I'm now trying to prove a negative. There is nothing in here that supports my learned friend's case, but you'll see it's only talking in this chapter about 382 to 384. So I wouldn't expect it to be saying anything about 55L. It talks about the you'll see the heading 2/3 of the way down the page, criteria for determining whether to exercise powers to obtain restitution. So this document is simply talking about when the FCA will use its power as a matter of policy. And then over the page at 283, see, the FCA will consider the number of persons who have suffered loss or other adverse effects and the extent of those losses or adverse effects, whether breach of a relevant requirement by a person, whether authorised or not, results in significant losses or losses to a large number of persons, which collectively are significant. It may be appropriate for the FCA to use its power to obtain restitution on their behalf. So, my lord, there is nothing in this guidance which either supports the fact that anything is being said restrictively about 55L. This only relates to talking about 382 to 384, or that 382 to 384 have something to do only with a large number of persons. It's made expressly clear that it applies where there are significant losses or losses to a large number of persons which are collectively significant. So, going back, as it were, to why we looked at all of this, it's because of what is said at paragraph 29 of my learned friend Skeleton, that this is one of those pre-legislative white papers that effectively gives a sufficient clue to aid our statutory construction. But the reality is, in my respectful submission, my lord, that the reference to the Financial Services Authority has existing powers to impose redress schemes on a firm-by-firm basis where a large number of consumers are affected clearly is consistent with my case being right that they existed through section 55L. And indeed also through section 382 to 384. It doesn't say there's one pre-existing power. But the idea that this somehow supports the proposition that you can that there was no pre-existing power, in my submission, is incorrect and unsustainable. And the reason I labour this is because it is a factor allied in the judgment, and returning, as it were, again to where we part company with the tribunal. One sees this at paragraph 301 to 302. And that's at page 294 of the court bundle. My lord, my lady sees at 301, the tribunal set out the white paper passage we just looked upon. They don't deal with why it's admissible, but they just take it into account. And they say 302, thus the intention was that the amendments to section 404 would introduce a new power to impose a redress scheme on a single firm. Last sentence, that new power to impose a redress scheme on a single firm only arose by virtue of section 404(7), which conferred a new broader power to vary permissions or authorizations under 55L. And in our respectful submission, the word thus simply does, there's no logic between what is said in the white paper, which refers to the pre-existing powers, and the conclusion drawn that effectively there was no pre-existing power under 55L.
So what was, in your submission, the government referring to when it said it believed that there should be new powers for the FSA to require a firm to make redress on a firm-by-firm basis?
In our respectful submission, I've shown the sort of rules, but obviously particularly relying on 404B and the power to bind the Ombudsman.
So it's the new powers in 404(7)
Precisely.
that you say couldn't have been done under 55L because that can only affect the firm and not third parties.
Precisely. And my lord, as I've shown in a number of those documents, the real important one is the Financial Ombudsman Scheme. Because unless you bind the Financial Ombudsman Scheme, then you'll be imposing a redress scheme on the firm, which covers exactly the same claims that might otherwise be brought to the Financial Ombudsman Service. So in that respect, it is an important new power. Now, I appreciate, and I've shown my argument in relation to why A is not redundant. I appreciate, and I have the court's point that if you crafted a requirement, you may well be able to get to all of those. I mean, you have my point on statutory construction, but in our submission, that's what's being said there. Obviously, the power on firms on an industry-wide basis is obviously the entirety of 404 which comes in, and previously was a power in the Treasury. But as far as the individual firms are concerned, we see in 404 F7 these extra powers to bind third parties, and particularly the Financial Ombudsman Service. And my Lord, similar points are then made by reference to what we have said, I think, in the skeleton, a sort of peripheral background material at best. If one goes to paragraphs 304 to 306 of the judgment just after, my Lord sees this construction is also consistent with subsequent legislation, which has referred to section 404 F7 as providing a separate power under which a section 55L requirement may be imposed. And yes, you can see the references, my lords, my lady, at 305 and 306. But that is entirely consistent with the distinction I have shown you in the FCA's own notices between a 55L only scheme, which only requires 55L because it doesn't bind the Ombudsman, and an Affinyon case, a 55L and 404 F7 case, which it requires both sets of powers because you are binding the Ombudsman. And in our respectful submission, those are entirely consistent with that, as is the passage then at 308 of the judgment. Now, my lord asked earlier about how much use as a matter of statutory construction we get out of the white paper. In my submission, there is no admissible guidance we get out of the FCA's own guidance on the statute. What one party thinks the statute means is not admissible as a matter of construction, and yet it is referred to quite a lot in these sections. But it's also consistent in our respectful submission with what we say. So does my lord see at 308? So soon after the FCA 2010 came into force, the authority released guidance on section 404 F7 in a document called Use of 404-7 Power on Single Firms. The guidance made it clear, it is said, the authority considered 407A to be a new power. But if one actually looks at the passage in my respectful submission, see in line 3, under section 404 F7, however, the FSA can impose on a single firm a scheme which corresponds to or is similar to a consumer redress scheme and enables such a scheme to include specific provisions that an industry-wide consumer redress scheme may include. The use of section 404 F7 is subject to different triggers from the industry-wide 404, namely the triggers that attach to the imposition of a VBOT under 44 and 45. Sorry. My lord, in our respectful submission, this is entirely consistent with our case, but where you have a 404 F7 scheme that binds the Ombudsman, and in a sense, regardless of what the source of that power is, the triggers for that condition are those set out in 55L, not those to be found elsewhere, such as the four conditions. As I say, in a sense, what our own guidance says about it is not going to be determinative or relevant as a matter of statutory construction, but that is what is clearly in our respectful submission being said here.
I mean, the triggers that are there being referred to are they the statutory objectives, for example?
Yes, the consumer protection objective, precisely, my lord, exactly. And that's why I said it was a two-stage step, two-stage test. First one needs to decide, is 404 F7 the source of this power? But even if it is, certainly in this guidance, what are the triggers for it? Well, the 55L triggers in our respectful submission. Even if that's where it came from in the first place, you are directed to 55L for the triggers, not somewhere else. And if one looks at the last paragraph of the quotation, in advance of this publication, the FSA can and will use its powers under 404 F7 where appropriate in respect of individual firms where there is potential for mass claims for consumers on a single issue. As the FSA plans to consult on the matter, our policy on the use of 404 F7 will be subject to change. And it's those mass claims that brings in this parallel route of the Ombudsman and explains why it's, when 404 F7 is used, it is because they need to bind the Ombudsman. So that is a passage from 2011. It's then updated, and again, all of this is taken into quite great account by the tribunal, which we certainly didn't say it was admissible or helpful, but one sees again at 309 and 310, they then refer to 2016 guidance, which is Conrad 16. And one can pick that up in the authorities bundle at A1, at authorities bundle, tab 23, page 413. So, my lord, this is the FCA guidance in a chapter called Conred, Consumer Redress. This specifically refers to the triggers that must be met under, before the FCA can impose a consumer redress scheme under section 4047. And you'll see at 1.83, my lord sees the letters, my lady, in the left-hand column. The relevant triggers for determining whether the FCA can require an authorised person with a permission to establish and operate a scheme which corresponds to or is similar to a consumer redress scheme are different to those that apply for an industry-wide consumer redress scheme established under section 404 of the Act. Rather than considering the test set out in section 404(1) of the Act, the FCA has to consider the relevant legal triggers for varying a permission or varying or imposing a requirement on a firm, see sections 55H, 55J and 55L of the Act.
You said that this was a chapter of the handbook.
My lord, yes. Sorry, it's the chapter of the FCA Handbook.
The FCA Handbook contains both rules and guidance, and the G in the box means this is guidance.
My lord, yes.
Does it have any particular status?
Well, my lord, as a matter of statutory construction, in my respectful submission, no. I mean,
it's just your attempt to explain to the industry what you think the Act does.
Precisely. I mean, there are obviously certain different areas where the FCA has rule-making powers.
Well, exactly.
But this is guidance on a statutory regime that says what it says and it means what it means. The FCA can't expand or restrict the ambit of 55L or 404 F7 on anyone's case.
Do the rulemaking powers not specifically authorise the giving of guidance?
Yes, my lord, that's right. That is right. That is right. But
so, in one sense, this is a statutory document under delegated
yes.
statutory powers.
Yes, I mean I accept that, my lord. Not least because, in my respectful submission, this is entirely consistent with the very case that I advance. And I mean, it's held against us. You'll have seen the tribunal go through these and say, well, it doesn't support what you say. But there is no meaningful distinction between the case I advance and what is said here in terms of where are the triggers, what gives you the power to impose one of these schemes. Well, you can read 1.83, not section 404, but section 55L, and that's my case in these proceedings.
Although I don't think you'd agree with 1.8.1.
Well, yes, and I mean, obviously those are matters, my lady, yes, and those are obviously, which is why we caution against taking the, taking too much account of the guidance. But my lady is absolutely right. At the risk of repetition, that's our two-stage test. this court will decide who is right on that 1.81 point. Did this power to put in a scheme at all exist before 404 F7? And that's question one. And if I'm wrong on that, you'll say 1.81 is right. But the second stage of that
So the question is, were you right when you wrote this, or are you right now?
my lord, the question is, even if your my lord's obviously right, but the way I would put it for this two-stage test is I say I'm right about 1.81, which means the word empower is infelicitous there. Envisages is much better.
Yeah.
Even if I'm wrong about that, we were definitely right when we wrote 1.83. Because however the power came in, the triggers as set out at 1.83 are those that we see in section 55L. And they are actually set out, as my lord sees, at 1.85. My lords have seen them, they're set out there. And then one goes over to 1.810, and this, in a sense, again reinforces the point I've been making about what 404 F7 really does. Circumstances in which the FCA will engage section 404B, as already explained, when determining whether to vary a firm's permission or impose a requirement under 55L to establish an operative scheme pursuant to section 404 F7, the statutory tests will be considered. But at 1.811, one sees the exercise will be undertaken on a case-by-case basis, looking at all of the proposed terms, including any terms which have been included to make provision corresponding to section 404B. And the court can see this passage as it goes through, but 1.812, if section 404B is engaged, then broadly the Ombudsman is normally required to decide a complaint refers to the Financial Ombudsman Service. And then it's likely that many 1.8.13, 4047, it is likely that many 4047 schemes will be set up. And amongst the considerations you see at little 2, the extent of any difference in redress between the proposed scheme and what consumers may receive through the FOS or the courts, for whether the FOS has had a material number of complaints about the act or omission, has an established approach to dealing with them, and the extent to which the proposed scheme aligns with this approach. So, to the extent that this guidance is of any assistance at all to this court in its task of statutory construction, I accept my lady is right. 1.81 is not something that I don't think was felicitously drafted. I don't think it's correct. But the meat of this, leaving aside where the source of the power came from, entirely reflects our case. This is from 2016. The triggers are those in section 55L. And whether you additionally use 404 F7 really depends on whether you want to bind the Ombudsman, which in many cases you will. But in our respectful submission, that is the extent of it. And may I show, my lords, my lady, at page 104 of the core bundle, paragraph 28.2b of our skeleton. We have this in the bundle, but maybe I just can read the passage. The statutory instruments were post-dated.
I'm so sorry, could you give me the reference again?
So it's page 104 of the core bundle.
Thank you.
So we have looked at statutory guidance. And we just make the point there in paragraph 28.2b that while the statutory instruments are in any event consistent with the FCA's analysis for the reasons set out above, it should also be noted that the courts have frequently stressed the need for delegated legislation to be roughly contemporaneous with the passing of the Act to be persuasive. So in addition to the FCA's own guidance, we say the statutory instruments are not helpful for that basis. So you have now had submissions, my lord, as to what 55L, as it originally was, section 45, that originally and always has allowed for this requirement to be imposed. Secondly, that on any view 55N, as it sits on the statute now, allows that to be imposed. And thirdly, that the source of the power was actually not 404F7. But I've referred on a number of occasions to the two-stage test, so I now want to assume against myself I'm wrong, and that actually 404F7 introduced it. I have my submissions as to why I say that's wrong, and 55N then just clarifies it. Even if that's right, why do the four conditions now govern a 55L, 55N, 404F7 scheme? Where do they come from? And there are really two different ways in which my learned friend has sought to put this case, and I think it's the second of them that has found most favour with the tribunal. But as the first one was the pleaded one, and the second one what the tribunal found, I will just briefly deal with both. So the first route is said to be section 404 itself, and that's back at page 173 of the bundle. I have already shown the court these three statutory triggers. Is there a widespread or regular failure by firms? Is there actionable damage? Do we want to impose rules? And what was originally said, and we could perhaps pick it up in the page 528 of the supplementary volume of documents. That's at tab 14 of supplementary volume 2. So this is from the pleaded case of the applicant as originally set out. You see it says here, by virtue of the stipulation contained in section 404F7 that a scheme required under 55L2 must correspond to or be similar to a consumer redress scheme under 4041, and you have my submissions as to why there is no such stipulation. The authority may only make such a scheme where, at least as relevant to the FSN, there has been a widespread or regular failure by the firm to comply with regulatory requirements. Consumers have suffered loss or damage in respect of which a remedy or relief would be available if they brought legal proceedings, and see that the authority considers that it's desirable to exercise the power. And my lord will see that those are indeed the statutory triggers for a multi-firm scheme in 404F1. And so the relatively straightforward case of BlueCrest as a pleaded case is set out at over the page at 529. None of A, B or C is satisfied in this case as a matter of law or fact. They're just reading across the actionability criteria from 4041B, even though that is applicable only to a multi-firm scheme. Why should it be incorporated into 404F7 and 55L, even if the power originally comes from 404F7? But
you accept there is an actionability criterion for a multi-firm scheme.
4041B.
Yeah. That's
unless my lord is going to tell me.
No.
But
it's just that so many things are disputed.
Yes, that I accept, and I accept that. So you cannot have a multi-firm 404 scheme for breach of a Principle 8 only. That is accepted. The issue is whether, assuming, or whichever route the source of the power, assuming you use 404F7 to have a single firm scheme, is actionability one of the criteria. And a more sophisticated, or certainly more complicated argument is developed during the hearing below, which the tribunal accepts. And we see that at page 291 of the core bundle. And this is paragraph 284. So I showed you 283 earlier. That's where they say, well, we're satisfied 55N can't just mean what it's 55L can't just mean what it seems to say. That's unreasonable or absurd. So we then have this. We are satisfied that the power in section 55L is in fact constrained as set out below by the terms of section 404F7 and the rules under section 404, namely section 404A. These provisions require the authority to establish the four conditions BCME UK BlueCrest contends, namely causation, loss, duty and actionability, before a redress requirement may be imposed on a single firm. So the tribunal's reasoning, if you chase through those sections, ends at 404A. That is where they say these four conditions come from. And we can see that set out at 319 to 321.
Paragraphs.
I do apologise, those are paragraphs, and page 298 was my page reference. The requirements that the authority is permitted to impose when requiring a single firm to conduct a consumer redress scheme under section 55L and under 404 F7A are those that may be imposed by way of rules made under section 404, which are provided for in 404A. And where they, so the argument seems to be that on their construction of 404 F7, they say the FCA may only impose this type of scheme if it imposes rules which could have been made under 404 and otherwise it can't do it at all. I think that's what the argument they sort of, the tribunal accepts. And so one looks at page 176 of the authorities bundle to see what 404A actually says. And it's possible to keep a finger in the judgment so we can try and track through the tribunal's reasoning as to where they come from. It's set out at 319 to 328 in relation to the what are said to be the loss, breach of duty and causation criteria, i.e. everything but the actionability criteria. And one sees that the judgment ends at 328 in this regard. Accordingly, section 404F7, sorry, it's page 299, paragraph 328. Accordingly, section 404F7 imports into a single firm redress scheme the requirement to prescribe conditions which correspond to rules that could be made under 404A1C, which necessitate that the authority may only impose on a requirement on the firm to pay redress where the customers of the firm have suffered loss which has been caused by a breach of duty, a failure to comply with a requirement. Well, my lords will, and my lady, will look at 4041C itself, but it does not, on its face, look like it is saying anything about what you can or cannot do in order to impose a scheme in the first place. This just says you can make that the rules may make, it's at page 176, may set out in relation to any specified description of case, matters to be taken into account or steps to be taken by relevant firms for the purpose of assessing evidence as to a failure to comply with a requirement, or determining whether such a failure has caused or may cause loss or damage to consumers. So these simply set out what one might call as procedural steps as to how evidential assessments are made. And in any event, far from imposing a requirement of loss, one of the things you might make your rule for is that it may cause loss. And my lord sees that from 1C2. So in my respectful submission, it is extremely difficult to understand how, even if one's right that 404F7 is the source of the power to impose a single firm redress scheme, these limitations are incorporated by means of 404AC.
They don't rely on any other provision in 404.
Not for these three criteria. Actionability is different, but for this one, perhaps it's
It's 1C.
yeah, my lord, my lady. I mean, one can go. I don't want to be unfair to the tribunal. So if we've kept our 3 our judgment at page 298, you can see they set out 404. 321, they say we consider that corresponding statutory conditions must be satisfied in order to impose a single firm redress scheme under 404 F7A, through provisions which correspond to those that could be provided in rules made under section 404. They then set out the provision of C1, and at 324, subsection 404A1C therefore addresses the three corresponding conditions of breach of duty, failure to comply with the condition, causation and loss. And then they have some paragraphs explaining why I got it wrong in my submissions. And then at 328, the conclusion I showed my lady. Accordingly, section 404 F7 imports into a single firm redress scheme the requirement to prescribe conditions which correspond to rules that could only be made under 404A1C. And our respectful submission is you just can't get that from that. It's not what 404A1C says. It's not what it's doing. It's not what it's intended to do. And it is simply unsustainable as a matter of statutory construction to go from 404 F7, even if it is the source of the power, to say that these provisions have this rules. As I say, it says may suffer loss, and there is nothing in there that has anything to do with the duty criterion. This sort of idea about, as I say, sort of akin to a duty of care point or a privity of contract point. Nothing in there that has anything to do with that.
I thought they were equating failure to comply with requirements as a duty.
It's a duty, but the way they put the duty criteria is a shorthand for this idea that the duty that must have been breached and the loss must have been suffered must be the person to whom the duty was owed. I might be doing injustice to my learned friend's sophisticated third condition, but it's more than you've breached a requirement. The duty point is this, as I say, in contract we'd be calling it a privity of contract point. In tort it would be probably a duty of care type point. But there doesn't seem to have any analogous rationale in this system, and indeed certainly isn't said in 1C. So yes, for the three conditions that have been incorporated, they rely solely on 404A 1C. And then for actionability, we have to go to para 329 of the judgment. And it says this: the fourth necessary condition is contained in section 404A3, which provides that matters may not be set out in the rules as a result of subsection 1C if they have not been or would not be taken into account by a court or tribunal for the purpose mentioned there. And my lord and my lady will recall that 1C, and if you do have it open, it's back at 176, refers to setting out ways you assess evidence as to failure to comply and determining whether such a failure has caused loss. And then what this provision is saying, well, you can't make rules that allow you to assess evidence in a way that wouldn't be taken into by a court or tribunal. What, in my respectful if somewhat rhetorical submission, has that got to do with incorporating an actionability criteria into these rules? Because what conditions a court would take into, or court or tribunal would take into account when determining whether there has been a breach of principal aid has nothing to do with whether that court or tribunal can consider a breach of principal aid in the first place. It's just got nothing to do with actionability. And of course, courts or tribunals do consider whether there has been a breach of principal aid. Obviously, the Upper Tribunal does it in its regulatory context. But the court may recall we looked at section 382 earlier and the restitution orders. The court may, on the application of the FCA, if it's satisfied that a person has contravened a relevant requirement, make the orders we looked at. Principle 8 is indubitably, this is common ground, a relevant requirement. So all that the 404A provision can be saying is that when you make rules, you can't take into account matters that a court would not take into account for that purpose. And there may not be things that a court would not take into account for the purpose of seeing if Principle 8 had been breached. But that has nothing to do with saying you can't set up a scheme in the first place based on breach of a principle.
But I thought you accepted that section 404(1)(b) did.
I accept that. I accept that.
So if you can only have a consumer redress scheme under section 404 if the breach is actionable, then why is the tribunal wrong to say if your 404A7 7F scheme has to correspond with it, it also has a requirement of actionability?
In my respectful submission, my Lord will obviously consider the judgment, that is not what the tribunal did, although that was the pleaded case, as I showed you earlier. BlueCrest effectively said, you just read across from 404, and that would include actionability. The difficulty I think the tribunal had with reading across from 404 is they accepted you can't read across a widespread or regular failure by relevant firms, because that just doesn't apply to a single firm redress scheme. And you can't read across from subparagraph C, it's desirable to make rules, because that's not what's being done in this case. So that's why the tribunal accepted, I think, because they don't endorse the argument, that you can't just read across 404(1)(b, because there's no route to that in 404(f)(7). If one assumes for these purposes that 404(f)(7) was the source of the power to impose a scheme which a single firm scheme which corresponds to or is similar to a 404 scheme, then whilst it may be corresponding or similar, by definition it can't satisfy 1A, which certainly won't satisfy 1C if there's only one firm, and that I think is why, and in my respectful submission correctly, one can't just read 1B across, one's literally picking it out of nowhere. So what the tribunal did was to say, well, we're not going to do that. We're going to find these rules. Going back to 404(f)(7), we are going to, as I say, look at subparagraph A, which says, if the FCA does this, it may include permission or authorization as varied, including provision imposing requirements corresponding to those that could be included in rules made under 404. And they have then said that, well, firstly, the FCA can't do this at all unless it has a 404(7) power. Secondly, the FCA has to impose matters which fall within the rules in 404A. And thirdly, for the purposes of the actionability criteria, and this is what is said at paragraph 329 and 330 of the judgment, it is 404A3. Matters may not be set out in the rules if they have not been or would not be taken into account by a court or tribunal for the purpose mentioned here, which gets in the actionability criteria. And in my submission,
Well, there's a direct route to 404A rules in 404(f)(7) itself. If you're wrong on your first point, and the power is only to do what is authorised in 404(f)(7), then that only authorises you to impose requirements corresponding to those that could be included in rules made under section 404.
precisely.
C7A, and that takes you straight through to 404A.
Precisely.
So that's the tribunal's route.
Exactly. But in doing that, they have not simply read across the three criteria from 404. They've used the rule-making power as their route.
Yes.
And the submission I advance is, I understand that's what they've done, but it's not a permissible, even if you are with every other strand of the way, when you get to 404A, and particularly subsection 3, that doesn't give you the actionability criteria. It's just addressing a completely different issue.
Well,
in my
I
submission.
mean, you say it doesn't give you any of the criteria, don't you?
Yes, I say,
You say in particular actionability.
I do,
because
and
that maybe suits your case, but
yes, I mean, in fairness,
you say you make the point.
for all of them,
You do make the point.
I'd make the point for all of them. The reason I draw a distinction isn't just for those cynical reasons, but because the tribunal itself, and you can see this at paragraph 328 of the judgment, we can clearly see that they get the first three criteria from one provision, 404A1C. And then paragraph 330 of the judgment, they get the actionability criteria from somewhere different, which is 404A3.
But this is all very odd because the rules under section 404A are all supplementary to section 404, and the rules are made under section 404, so they're all dealing with consumer redress schemes where there's a condition of actionability.
My lord, yes.
But it seems very odd to say, oh, well, you have to correspond to a 404A, but you can do something which you couldn't do under 404A, which is impose consumer redress schemes which require redress to be paid in respect of failures to comply with requirements that weren't actionable, because that seems to be quite different from what you're doing under 404A.
My lord, in a sense, yes, and I'm trying to identify each of the stages of the decision which the tribunal has reached. But on this analysis, and on the basis of the tribunal's word reasoning, odd though it is, that is what they have done. They said, 4047 has this direct route, as my lord put it, which gets us through to the rulemaking power in 404A, and it's that which we have then relied on. And my lord has my submissions on that. But in my submission, there is no basis either, which is why I dealt with both cases, for saying that 404F7
requires you to have the same provisions.
precisely.
You say it's permissive.
A, it's permissive, but B, logically, it can't, because two of those provisions simply aren't going to come up in a single firm redress scheme, because you're not going to have a widespread failure by firms. That's the whole point of it being, and you'll see in 4047, this is a single firm scheme, authorisation of a person, so you're not going to have that correspondence, and nor are you going to have the correspondence of the rules, the desirability to make rules, as set out in 4041C.
Well, I understand the first point. I mean, obviously, if you make a single firm redress scheme which corresponds with a multi-firm consumer redress scheme, it has to be adapted mutatis mutandis, and one of the things that has to be changed is whether there's a widespread failure or not. I haven't quite understood your submission in relation to C. Why can't you say the corresponding requirement is it's desirable to make a scheme for the purpose of securing that redress is made to the consumers of that firm?
Well, in my respectful submission, the desirability to make rules, as opposed to imposing requirements on a single person, is something that the rules are a scheme which will apply, if I can put it that way, across the board, and that's why we see them set out in some detail at section 404A. So in my respectful submission, and I entirely accept the FCA may consider it wishes to make rules in relation to a single person scheme, but it's not something that can sensibly simply be read across any more than one can read across an actionability criteria.
I mean, 7A specifically talks about imposing requirements corresponding to what could be included
in the rules,
which rather
precisely.
suggests that it's something different.
My lord, my lady, I mean, as I say, the tribunal have clearly dealt with it in a particular way, but I can quite see that the way that it can alternatively be posited, that one simply goes back into section 404. But in my respectful submission, as we have said, it's clearly a permissive provision. I mean, that's our primary submission, as my lady knows. But in the alternative to that, it doesn't make sense in our respectful submission to say that in order to correspond to or be similar to, in order to be permissible at all, you need to have the three criteria in 4041 for the reasons I've set out. And therefore, even if the tribunal's right to look at rules making power under 404A there's nothing there that incorporates actionability.
Just going back to F7, there are on any basis two parts to it. We have the submission on if, but
Yeah.
let's just say the first part enables a scheme corresponding to or similar to a redress scheme. Then it goes on to say things that may be included. They includes it. That is not an exclusive list
Precisely.
either.
No, my lord. I mean, lady, that's our
Is not to be.
precisely. That's our, in a sense our submission that the tribunal have characterised this as being exclusive. These are the only things that you can do, and that's not what the statute says.
So it's by treating it as an exclusive list
Precisely.
that they use subparagraph A.
Precisely.
What do you say? They
Yeah.
use
So on the hypothesis against myself, 4047 creates the power on this basis. But it then takes away much of what would otherwise be within that power by reading the provision that may be included as an exhaustive list, as my lady has said.
So are there three stages to your
Yeah.
argument rather than two? The first is because of the if, this isn't where you find the power at all.
Yeah.
Secondly, if that's wrong and you find the power here, all that the second half is doing is a non-exclusive list of things that can be included
Precisely.
and doesn't mean that you can't do something that is not something that could be included in rules made under section 404.
Precisely.
And then the third is that if you're wrong about that, there's nothing in 404A which identifies what can be included in rules under 404, which imposes any of the four elements.
Precisely, my lord. And it's in that third stage that one gets this subdivision about, well, can one get a bit from 404 and a bit from 404A, which isn't the way the tribunal have done it, but for the reasons I've given, I say neither is permissible if I'm wrong on stages A and B.
So can I just be sure about this, because you showed us earlier by reference to the TFS and the other scheme, that sometimes you just use your powers under 55L, sometimes you expressly do use your powers under 55L and 404F7 because you want to bring in the ombudsman scheme. And you say that even in the latter cases, where you are undoubtedly using some power that's in 404F7, you still are not constrained by the four requirements which would be there for a consumer redress scheme.
Precisely, for the reasons set out, if I may adopt, at stages 1, 2 and 3. But my lord is right.
Well, it's only
Well, it's only 2 and 3.
It's only two.
It's only
Yes,
two
no,
it's only
yes,
2 and
exactly.
3 in my lord's
Yes,
example.
exactly.
Yes.
Exactly. But it's both that it's permissive, stage 2, if I can gratefully adopt my lord's characterisation, and then stage 3, even if I'm wrong about that, I say you can't find them in 404A.
But at stage 3, one does have to interpret what is permitted by rules under 404, and those rules, or the content of such rules, namely what's in 404A, have to be interpreted, don't they, against the background that they are rules made in circumstances where 4041B applies.
Well, yes, I don't, in a sense, there are two competing positions here. My submission is that, in a sense, if you're going to go down this route, which I suggest shouldn't, but 404A, one just has to read it on its terms. It allows for rules to be made dealing with quite specific matters, how you assess evidence, who you can authorise to do things. I understand it's made under 404, but my submission is you just read the rules, if you're going down this route, as they are drafted, and if you read them on their face, 404A3 simply doesn't incorporate actionability. I also accept, my lord, I understand the argument that if you look at it, if you say, oh, well, no, I'm going to read in addition to 404A that you can only make them if 404 is satisfied, you've got your actionability because you've brought 404 in. But of course, you're then incorporating subsection B, actionability, in circumstances where you're not incorporating subsection A, widespread or regular failure. So, my lord, I entirely accept that would be the route, but in my submission, it would not be the correct approach to statutory construction. My lord, those in a sense are the provisions relied upon by the parties as the principal matters. I say I have sections 55L and 55N front and centre of my case. My learned friend draws attention particularly to 404F7 and 404A and 404 itself. There are other provisions referred to in the judgment, which both sides and the tribunal highlighted for contextual effect. And may I just briefly list them so that and show them so that my lord and the courts have them. So we start with 382 and 384, which my lord and the court have looked at. So this is the restitutionary power. Now, can I just draw attention? They are in similar terms, but 382 is the one that the court may adopt. You see, the court may make such an order if satisfied that profits have accrued to him, or that one or more persons have suffered loss or been otherwise adversely affected. So it's not restricted to loss, and indeed, as was pointed out earlier by my Lord Justice Nugee, it also operates in circumstances where profits have been made that can be stripped. There is obviously nothing here which would mirror the fourth condition. You can bring a section 382 claim on the basis of a principle, and the FCA has done so. But nor is there anything, as we can see, that would restrict it to the four conditions that we have, because loss is defined not just as loss, but other people's profits and other adverse effects. And my lord will see that the order that the court may make is not some correspondence to loss as the English common law understands it, or causation as the English common law understands it, or the third breach of duty condition as it's put. The court may order the person concerned to pay such sum as appears to the court to be just, having regard to, but not necessarily equating to, the profits appearing to the court to have accrued, the extent of the loss or other adverse effects.
Why do you apply to court if under 384 you've got power to impose things yourself?
I will take instructions on that. I have been involved in both situations, and that's it. 3841 refers in the page 141, does my lord see if it's satisfied that an authorised person has contravened a relevant requirement?
Yes.
That's the authority. 382, you'll see that in subsection 1, if it's satisfied that a person has contravened a relevant requirement. So the court has a wider power in terms of the ambit of people that can be brought within it. But in terms of the other provisions, as we have seen, they are the same, and one can see the way this has been dealt with in the authorities if one happens to have tab 55, page 1541. Avocard, which is an example of a 382 case.
So sorry, I was just looking at something else. Just give me the reference again.
Tab 55, page 1540 in the authorities bundle.
Thank you.
This is FCA and Avocade, which is a case under 382 in the application to court. Just show paragraph 31. Section 3822 confers a wide remedial discretion upon the court to make an order for such sum as appears to the court to be just. And then in paragraph 33, it is clear that section 3822 is not intended to replicate the common law regime for quantification of damages. It is much broader and looser in operation. And the reason that I draw these matters to this court's attention.
Was this the case that went on appeal to a court of which I was a member?
If my lord recalls it, I'm sure it did, but
I was involved in a decision involving Applicant.
my lord, I will check. I don't believe it says anything about the principles of quantum in any further case, but I'll make sure that is checked.
It's more embarrassing for me that I can't remember enough about it than it is for you. But there we are.
But I mean, it's plain from the statutory wording where you have such summaries as just having regard to these factors. And the reason I show that is because of paragraph 236 of the tribunal's judgment, a paragraph which we've looked at earlier in a different context. So this is back at page 282 of the core bundle. So if one looks at paragraph 226,
226.
I apologise, it's page 281, paragraph 226. It is necessary to consider the history and development of FSMA in order to construe its current scope and the powers that might be available to impose a consumer redress requirement on a single firm. As originally enacted, FSMA provided four means by which clients or customers of authorised firms could obtain redress where breaches of certain regulatory rules were established. And they go through them. One of them is 404. One of them is effectively a civil claim, a breach of statutory duty claim. You'll see at 231, the second one is this redress requirement in 382. And then they conclude at paragraph 236. As set out above, each of the four powers of redress, as originally set out in FSMA, required the authority, or the FOS, to establish at a minimum that a person had suffered loss, B, that, well, these are the three criteria, the first three criteria. And in my respect, and it's this conclusion that effectively informs the tribunal's reasoning that you have to read the power to impose a single firm redress scheme consistent with all of the other provisions that they have referred to here. But as I have shown this court, in my respectful submission, 382 and 384 plainly do not have the conditions, these three conditions incorporated into them. It's loss or other adverse effect or indeed profit stripping. And it's not a causation requirement, let alone a correspondence between duty owed and person who suffered the adverse effect. It is such figure as is just having regard to those relevant matters. So in our respectful submission, this was another false turning by the tribunal in their statutory construction. And we make similar points in relation to the reference to the FOS, which is another of their four original requirements here. And again, my lord, one can see at page 123 of the first bundle of the authorities bundle, this is the financial ombudsman scheme, which is relatively familiar.
Page 123.
123. So here we see section 2282. A complaint is to be determined by reference to what is, in the opinion of the Ombudsman, fair and reasonable in all the circumstances of the case. And then at 229. And then at 2292, if a complaint has been dealt with under the scheme is determined in favour of the complainant, the determination may include an award against the respondent for such amount as the Ombudsman considers fair compensation for loss or damage of a kind falling within subsection 3. And 3, a money award may compensate for financial loss or any other loss, this is subsection B, or any damage of a specified kind. And the FCA has specified various kinds of damage within its COBS rules and specifically indicated, and I'll just quote them, we can hand up later, financial loss, pain and suffering, damage to reputation or distress or inconvenience, whether or not a court would award compensation, and that's COBS 3.7.2. So in both of these other forms of redress, there is an extremely wide methodology permitted, which has no correspondence, it is much wider than that set out in the common law, and which in my submission makes it clear that there was no, it was wrong to take into account, as the tribunal did, some idea that at the start of FSMA, when it was first enacted, there was some correspondence between all of these different provisions, such that it makes sense to read the 3 or 4 conditions into the statute in the way that they have for a single firm redress scheme. And finally, my lord, by way of statutory provisions, if one goes to page 196,
Can I just ask, just going back to 384,
my lady, yes.
that presumably among the FCA would say among its armoury in this case might have been
Yes.
the ability to use.
My lady, yes.
For,
My lady, yes.
but you say it chose not to.
My lady, I do. And with respect to my lady's question, is a useful segue, if I may, to Authorities Bundle, page 196, which is the final statutory provision.
So that was where you were taking us, was it?
My lady, yes, no, it's helpful because this is section 415A, which is an express provision that any power which the FCA has under any provision of this Act is not limited in any way by any other power which it has under any other provision of this Act. So in my respectful submission, that clarifies the fact that in the toolkit, which is a phrase commonly used by the regulator, yes, it may well be a case in a certain situation that you can choose between a 55L requirement or a restitution order, or of course other disciplinary measures, or effectively inviting people to bring claims to the Financial Ombudsman Service of their own back. These are tools within the armoury. It's expressly provided that one does not restrict the other. So my respectful submission, when one stands back from these statutory provisions, one has a clear pre-existing requirement in 55L. It's even clearer as the statute now stands in 55N. That source of the power is not 404F7. And then my lord has, as I adopt the 3 stages effectively, that 404F7 we can see isn't the source because of the use of the word if. But in any event, that which is set out, the provisions that may be included as permissive. And finally, you have the arguments in relation to what 404A provides in the first place. And 415A in our respectful submission is a helpful provision to remind the court that it was not intended that these schemes, that these provisions somehow restrict each other. That effectively, if you identified a power that could be used in one case, that either meant all the others had to be used in the same way and subject to the same restrictions, or that there couldn't be potentially duplicative and overlapping powers. And finally, in this regard.
So what do you say the aim of, it's pretty self-evident, you say the intention of including 415A, which presumably wasn't in the original legislation, is just that, to clarify that,
Precisely.
that yes, we all know these powers overlap,
Yes.
but
that does not.
That doesn't restrict their ambit.
Yes, and I think I put it this way before. I mean, it's to make express the caution that, in my respectful submission, a court should adopt when it seeks to effectively compartmentalise different powers. It's saying no. These powers may well overlap. Do not read things down by reference to other powers. And particularly, do not, as in my respectful submission this tribunal have done, read down 55L by the sort of stepping stones which we have gone through this morning. There's one other matter which the tribunal focus on, which in my respectful submission they are wrong to do so, and it's a related reason. They say it would be absurd and unreasonable if 55L had this effect because we could just impose hundreds of single firm schemes and thereby get around the provisions of a multi-firm scheme under 404. And in my submission, that is not a legitimate aid to statutory construction, especially in circumstances where you have 415A that makes clear that one power is not to be read down by the existence of another power. But it also, in my respectful submission, doesn't take us anywhere in these circumstances. If it were to be said there was a deliberate attempt to subvert the purpose of a statute by bringing a multiplicity of schemes, that might be an argument for another case and another day. No one can suggest that here. This is clearly one firm and a breach very specific to the firm itself.
Is there also a difference in that the consumer redress schemes under 404 don't require you to have reached a conclusion that every single firm, including the scheme, has acted in breach of requirements. All you need is a widespread failure.
Yes.
So if you take something like pensions mis-selling, which was a widespread failure, it's possible that there were firms who never mis-sold a pension and
Exactly.
always gave the right advice. But they could still be required to go through the scheme and check everybody's paperwork, but you couldn't do that if you're doing it firm by firm in the same way.
Well, it would be irrational,
Well, it'd be more
potentially irrational.
It'd be more difficult to do it.
Precisely. I mean, this submission was rejected below, but I nonetheless make it again, that there are, in my submission, obvious reasons why you would impose potentially particular criteria, potentially more stringent criteria, where you're doing something that affects the entire industry and where, as my lord has said, you are not asserting a breach yourself. You know, in this case, we say you've breached it, we'll prove that in the tribunal. As my lord has said, it may well be that many of these firms are being required to fund expensive investigations when they have breached nothing, and it's not being said that they've breached anything. It's a very different trigger.
So Section 404 itself says one of the things you can require in a consumer redress scheme is for the firms to do the investigation.
Precisely.
See whether there's been a breach.
Precisely. And the other point in this regard is, I mean, you could say the same thing about 384, that you could bring multiple claims onto those in order to evade the 404 scheme. As I say, there may in different cases be subversion of purpose arguments, but in the light of 415A, there is not, in my respectful submission, any reason to what I say is an artificial incorporation of these four conditions into this statute. Now, my lords, my lady, mindful of the appropriate practice direction, and indeed you've been listening to me for far too long, I was going to invite Mr. Rattan to deal with the respondent's notice points, which are effectively, well, even if you're with me on statutory construction, there are human rights arguments and various ways. So if my lords are, my lady is content with that, I will ask him to.
Yes, just before you sit down, can I just raise one point on 404? The consumer redress schemes have to be implemented by the FCA making rules rather than simply imposing it. Why is that? Is there some consultation process, for example, that's required for rulemaking?
Well, we can see under 404 404.9, if we can pick it up again. At 174, that before making rules under this section, the FCA must consult the scheme operator of the Ombudsman scheme. So there is that consultation requirement.
But my point's to a slightly different one, which is one might have expected that you could just as easily provide that the FCA could itself impose a market-wide consumer redress scheme without having to make rules in order to do so. But that isn't what's provided for. What's the rationale, if any, for requiring rulemaking for a
Well,
consumer redress scheme that's market-wide?
Take instructions, because I suspect there is an actual answer to that, which those behind me will know. I mean, what I could obviously
Come back to it in due
exactly,
course.
but obviously posit the situation that for transparency purposes, when many different firms are being affected, it would provide a consistency that people will be able to see that the rules, which are supposed to require for each relevant firm, are being applied in a consistent and transparent manner. But I'll take instructions. As you know, 404 itself replaced a provision that required the Treasury and Parliament to be involved in this type of scheme. So it may have developed out of that, but I'll take instructions.
Thank you.
Mr. Ratner.
Yes, Mr. Ratram.
My lords, my lady, I'll be addressing you on a number of points raised by BlueCrest in its respondent's notice in respect of ground one. For your note and for the transcript, they're addressed in BlueCrest skeleton argument at paragraphs 50 to 67, and the FCA's reply skeleton argument at paragraphs 3 to 18. They fall under three headings. First, the right to peaceful enjoyment of possessions under Article 1, Protocol 1, the ECHR. Second, what BlueCrest describes as common law principles on statutory interference with economic interests. And thirdly, alleged unlawful exercise of statutory power for an improper purpose. I'll endeavour to deal with these as speedily as I can. For context, these are points which Mr. Herberg below largely left to his skeleton argument rather than developing orally. Obviously, the oddity of the timetable is now I'm effectively opening them, so that might be regarded as indicative of the limited significance they have. Before I deal with them specifically in turn, I make the following four overarching points to help clear the ground. First, a number of the respondents' notice points are directed towards a straw man in that they characterise the FCA's case on statutory construction as giving rise to an entirely unconstrained power. The phrase used by BlueCrest in its skeleton argument at paragraph 57C is to say on the FCA's case it would be entirely at large. But to be clear, that's not so. And it's a point Mr. George has made, and it's in our skeleton argument, paragraph 21, so I won't labour it, but I do need to highlight it. Of course, on the FCA's case, the Section 55L power remains subject to the express conditions for its exercise, including that the FCA considers it desirable to impose the requirement in order to advance one of its statutory objectives, here the consumer protection objective. And as we set out in paragraph 21.1, the FCA accepts that it must adopt a rational approach when determining whether those express conditions are satisfied. And that includes a rational assessment, identification and assessment of any loss caused by a regulatory breach, where what is imposed is a requirement that redress be paid to compensate consumers. And that is an important point to underscore, because actually, once that's appreciated, many of the respondents' notice points really melt away because they're tilting at a false target, namely an entirely unconstrained power. Second overarching point, on a related theme, a number of BlueCrest's points are premised on the assertion that the redress requirement imposed by the authority in this case does not in fact compensate for any loss. And to be clear, that's a point on which BlueCrest lost below, and for your note, that's in the Upper Tribunal judgment at paragraphs 351 to 363. BlueCrest challenges that aspect of the tribunal's reasoning, and that's a point Mr. George will be addressing you on later. I don't need to say more about it for present purposes, other than to note the high degree of overlap. Essentially, BlueCrest says you've identified no loss, and that's the point they lost on below. They further say, because you've identified no loss, your approach is not in the public interest, it's disproportionate, and it amounts to an unlawful exercise of statutory power. And those are the points that weren't determined below, and on which I'll be addressing you. And I say simply this, while BlueCrest has been assiduous in respelling that point in all of the ways that it could be spelled out, it does remain essentially the same point. Third overarching observation, it's important to be clear about what precisely is the punchline that BlueCrest is seeking to derive from its respondents' notice points insofar as statutory construction is concerned. Because your lordships will recall that BlueCrest contends that the Section 55L power must be understood as subject to four conditions: loss, causation, actionability, and what BlueCrest describes as a duty condition, but perhaps more precisely would be described as a correspondence condition, because what's required is correspondence between the person to whom the duty is owed and the person by whom the loss is suffered. But insofar as one can discern from their skeleton, BlueCrest doesn't even suggest that all four of those conditions could be derived from the respondents' notice points that I'm addressing. In particular, in relation to the human rights argument, the highest it's put is that 3 of the conditions could be derived, namely loss, causation, and duty. And you can see that in BlueCrest skeleton at paragraphs 50 and 58. And those are, of course, the 3 conditions which the Upper Tribunal held that the FCA's case satisfied in any event. Fourth and final overarching observation. Insofar as the respondent's notice goes beyond arguments as to statutory construction, it's important to be clear about the footing on which those arguments are being advanced. As we set out in the FCA's reply skeleton in paragraph 12, the present appeal arises from an application by BlueCrest for strikeout, alternatively summary determination, of the FCA's case on redress. So there haven't been any factual findings made below. And so that is relevant to take into account when one comes on to consider, for example, BlueCrest's arguments on proportionality. What BlueCrest would need to establish is that the FCA lacks any real prospect of establishing at the final hearing that the requirement in this case was proportionate. And obviously the question of proportionality is a highly fact-sensitive one. We say it's not one that was determined by the tribunal below, and it couldn't possibly be the subject of a ruling on appeal without any of the relevant factual findings having been made. So, my lords, my lady, that's the preamble. I'll move on now to address in turn each of the 3 areas that I outlined, beginning with Article 1, Protocol 1, ECHR. And we can pick this up in the FCA's reply skeleton at paragraph 5, that's core bundle, tab 13, page 207. And what we there lay out is some groundwork, because effectively what BlueCrest are relying on is the interpretive obligation in section 3 of the Human Rights Act to interpret legislation compatibly with convention rights so far as possible. And what we set out in paragraph 5, which I don't believe is contentious, is the structured nature of that inquiry and the hurdles that my learned friend would need to surmount. He would need to show first that the FCA's proposed interpretation was in some sense incompatible with Article 1, Protocol 1, and even if that could be established, any interpretive modification would have to be limited to the minimum necessary. So it's not some kind of freewheeling comparative exercise where one stands back and looks at the competing constructions and asks which of them is, in a broad sense, more conducive to BlueCrest's right to its possessions. That's set out in the Friends of the Earth case, which we've noted in paragraph 5. You can then see from paragraph 7 of our reply skeleton, we've split this out into what the relevant disputed aspects are. We accept that the use of the section 55L power to impose a requirement engages the Article 1, Protocol 1 right. The disputed elements are first, as to whether that interference is in the public interest, second, whether it's provided for by law, and thirdly, the question of proportionality. As for the public interest, that's a very short point. We make it in paragraph 8 of our reply skeleton. In short, there can't be any serious room for dispute that the FCA's statutory consumer protection objective is in the public interest. Indeed, it is the articulation by Parliament in statute of an obviously important public interest. And as I've explained, the FCA's construction of section 55L remains expressly tethered to its statutory objective. So we simply don't understand on what basis it could be said the FCA's construction lacks the necessary connection to the public interest. Second element, provided for by law, we address this in paragraph 9 of our reply skeleton. Essentially, the question is whether the conditions for the exercise of the statutory power under section 55L are so uncertain that they're deprived of the quality of law. And we do draw attention to one authority on this, which very helpfully sets out the relevant principles for this legality test, this in accordance with law test. I'm conscious of the time. I don't know whether we want to break now. The authority will, I suspect, take more than 1 minute just to look at the relevant paragraph and outline the points, but I'm happy to either begin now and then break, or else to...
All right, let's break now then, and come back at 2 o'clock, please.
I'm very grateful.
All rise if able.